Torts. Torts is another umbrella type of law, like equitable remedies. And torts encompasses a group of laws that are matters in which one party has a duty of care which they have breached. And that's the basic definition of a tort. It's a form of civil law. We're going to do a number of torts that are specifically important in business law. The first one is false imprisonment, and you have the rule there. There are two things to think about when you discuss false imprisonment. The first is that word reasonable. We're going to see that word a lot this semester, and reasonable is a word to be very cautious of. Reasonable means what the 12 jurors will decide in a jury, or in the absence of a jury, what the judge decides. So it is not a standard I can define for you. It's a standard that's defined within the trial. That should give us all pause, because that means there's a lot of uncertainty around those legal causes of action that use that word. The other piece I want to point your attention to is what are your other options. Whether or not a restraint of someone is reasonable has a lot to do with other options. So in the classic case that I'm a store owner, I think someone has shoplifted, I saw them put something in their bag, and now I'm trying to decide if I should detain that person and search their bag. Well, detaining them is the restraint of someone without their consent. So we're going to get into what is reasonable, what are our other options. I could have surveillance cameras. That would be another option. I could have a security guard follow them to their car and talk to them at their car instead of within the shop, where it's still kind of murky whether or not they intend to take the merchandise without paying for it. So that's what a court is going to look at. Intentional infliction of emotional distress. This is a really fun tort. Courts hate it, so please use it sparingly. Think of the words extreme and outrageous in capital letters. The behavior has to be truly extreme and outrageous, and it also has to cause real and serious harm. It can't just be that your feelings were hurt or that you were bothered for the day. It has to have a serious impact. So if I follow my neighbor around as he's walking his dog and threaten to disembowel the dog and talk about how long the intestines are, and it's already disturbing me. So I've hit that extreme and outrageous behavior. But if my neighbor can demonstrate that this is causing him to have panic attacks and he can't leave the house, now we're talking about that serious emotional harm. Compare that to negligent infliction of emotional distress, and you'll see that these are very different torts. In negligent infliction of emotional distress, you have the test right here. It's a nice, neat, narrow test. I really like these kinds of torts because it's very easy to apply. Where we get interesting court cases is in part 3 of the test, in the definition of who is a close relative. In many American families today, a close relative is who you are most impacted by, I should say, is often not a close relative. You may not be close with your parents or your siblings, but you might have very good best friends who seeing them at the scene of an accident would be devastating. In California, there have been cases where a pet is considered a close relative. So that is where you would really have to spend some time arguing. Trespass. Trespass is a nifty little tort because there's a rule, but there's 2 rules, as you can see, with the giant or between them. And that means that either one is trespassing. So a classic example, I'm walking my dogs in open space, and unbeknownst to me, my dogs and I walk onto a private horse farm. That is trespass. Even if there is no fence, no sign, no indication that I have moved from open space to private property. The fact that I intentionally walked onto that property, I did it deliberately, makes it trespass. And then if the horse farmer comes out and she says, I hate dogs, get your dogs off my property, and I cannot corral them quickly back onto open space, that is also trespass because I'm refusing to leave the property. Conversion. Now, when you review this tort, I think you'll see that this is theft. So the question is, why do we have a tort for what we have a perfectly good criminal legal cause of action for? Theft. And the answer is, criminal causes of action may not make you whole again as a business. So if I'm working for you and you fire me and I walk off with my company-owned mobile and my company-owned laptop and I refuse to return them, you can file criminal charges of theft against me. And maybe I'll get probation, maybe. But what you want is your stuff back or the value of your stuff back. And maybe conversion will be easier, quicker, and quieter for you to achieve that. Intrusion. So, intrusion is a two-part test, as you can see. And what's important here is that the intrusion be into your private life and that it is offensive. So if I'm an actor and there's an intrusion into my private life that I'm gay, is that offensive? If I wanted that to be private, is that offensive? I would argue probably not today. If we take the very famous case of President Bill Clinton and his behavior in the Oval Office where he used a cigar in a sexual act, is that private? It is offensive in the sense that it's not the kind of thing you want others to know about you, but is it private? You could argue that the behavior that someone engages in the Oval Office, which is probably one of our most public spaces in terms of our mind, cannot be private. So that's how intrusion would work. False light requires that the statement be untrue. So a very simple example of false light would be to take the head of one person and put it on the naked body of another person, creating an untrue image. So I kind of imagine if we took Angela Merkel and we took her head and put it on a naked body, that would be false light, because an actor might help an actor's career if the naked body was appropriate for acting. But for Angela Merkel, who is of course a political head of state, that would create an image of her which would be detrimental to her career, or certainly not helpful. Now, disclosure of embarrassing private facts. This is a fun tort. Again, here's that two-part test. And if we just go back to President Clinton, it's such an easy one. The first thing I want to say is, yes, you can sue for more than one tort. They often do, plaintiffs in lawsuits. And here, you can certainly see that President Clinton's behavior was true and was embarrassing. But do we have no legitimate interest in that? That's an interesting question. Given the way the First Amendment freedom of the press has been identified, I would argue no. When we think about what is in the media about famous people every day, we are interested in if they use colonics. We are interested in what their workout routine is. It's hard in the United States to imagine a public figure having any private space at all in terms of the media coverage of public figures. Commercial exploitation, and here's the rule for this. The most famous case of this is with a dancer whose name was Fred Astaire. and there was an advertisement where they took his female partner out of the video and they replaced her with a vacuum. And then he appeared to be dancing with a vacuum in this advertisement. And they were sued successfully for commercial exploitation by his family. What's important here is that this is for a commercial purpose, like an advertisement. This isn't for regular speech, but for specifically commercial speech. And then the Lanham Act. Already you can tell this one's a little different because it is an act, which of course, remember, means a statute passed by a legislature, in this case federal statute. And here's the three-part test. Please note again, this is for commercial speech, like an advertisement. It is not for regular speech, but for specifically commercial speech. Battery and assault. This one, for some reason, sometimes in movies or television, this kind of gets flipped. So battery is the intentional touching. Assault is fear of the imminent touching. So if you notice also, intentional touching doesn't mean doesn't have to be a physical harm. I don't have to have a bruise or finger imprints or a cut. Any kind of touching that is intentional, offensive, or unwarranted, works. So, I am female, and if I have a male Muslim student and I am helping him with a case study and he is getting upset and I touch his shoulder, that might be offensive or unwarranted to him in his religious culture, in which case I have committed a battery. And assault, the important word fact in assault is imminent. So the fear has to be of a imminent or almost right now battery. So it can't be a text or a phone call. It has to be that I've got you in the corner and you're afraid that the next thing I'm going to do is that intentional touching. And those are the torts we're going to discuss today. Thank you.